Hello, you guys. Welcome back to my channel. My name is Najwa. If you are new here, please do me a favor. Join our community. We talk about all types of stuff. Go ahead and smash that subscribe button. Smash the bell so you know whenever I post a video. Let's talk about this next development in the Georgia RICO case. Now, for those of you who are new to the channel, you probably don't know my background. I am Najwa. I am from Alabama, but I grew up in Atlanta, Georgia, and but I live in Europe, but I am American of birth, and I still got my blue passport. So, this is very, very close to me. We are not just looking at election interference, as some people put it, or one person puts it. You know, this is trickling down from the top up. What we are in right now is we are in a bare knuckle fight to protect American democracy. And I gotta go ahead and admit it, myself included, present party included, Americans dropped the ball. You know, we are feeling the very real implications and symptoms of, over the past 7 years, watching American democracy deteriorate. You know, I have been feeling such shame and guilt just for being an American, period, for the past 7 years, which is so bizarre to me because for the first 25 years of my life, being an American was a great pride that I took. It still is. But right now, we are in a bare knuckle fight to protect American democracy, and I don't think that everybody really understands that. Basically, what we're protecting it from is authoritarianism, is you know, the attempt to protect the sanctity of democracy. And so that is something that we really need to be aware of. We need to know that that's what we're in the middle of here. Sorry, I'm putting my headphones on. And because we're going to watch this together, just like we did the first part. And I want to review it with you guys here in the present moment. I want to be with you in the present moment to discuss this because it is so much bigger than the way these people are making it out to be. They have the hallmarks of what Donald Trump has done for 7 years, which is do as I say, not as I do. It is to say something that sounds like the right thing, something that sounds perhaps even polite, that sounds like one is exercising their own rights of democracy. But layered within it is autocracy. Layered within it is authoritarianism. So this is the like what the prosecutors, the state prosecutors and the judges and the judge continue to put in perspective, that this is not just about Kenneth Chesebro, this is not just about Sidney Powell. They do a great job of putting this back into the global perspective of, dude, this is a guy who tried to overthrow American democracy, who did not want to go with the peaceful transition of power. And we have to keep, I mean, we're going to have to keep reiterating that, because I'll tell you what, MAGA is very good at distraction. You know, they're very good at sort of misdirection, where they talk very fast, they talk in a very high tone, you know, in a very inflated manner, and they come from a tone of being offended, come from a tone of feeling slighted and expressing that they feel slighted, and you essentially get distracted from the situation at hand. It's like watching a slow car wreck. It's like watching a slow train wreck. It is like watching O.J. Simpson in that white Bronco, and that's what's been happening for 7 years. You know, I honestly feel like when all of this is over, and trust me, it will all be over eventually, justice eventually works its way out, okay? Justice plays out. And again, I just want to go ahead and remind you guys, I'm not a lawyer. I am an everyday average person. But I have to speak out about these things on my channel to protect not only people who look like me, because anti-black sentiment has sprung up in America like nobody's business over the past 7 years. It was slow. It was slow burning, but now it's absolutely out of control. But it's not just anti-black sentiment. Anti-Jewish, anti-woman, anti-Asian, anti-Latino. It's like it's out of control. And, but honestly, it doesn't just come after people of color. It comes after everyone, you know. Authoritarianism has no end. It has no end until it gets to a dictatorship, you know. And then you got people rigging planes and crap, planes falling out of the sky. That's what this all leads to, is a dictatorship. That's not America. Again, if that's what you want, go somewhere else. That is not American democracy. The problem is, we have to essentially think about where this is taking us. You know, like, we have forgotten where this is taking us. We think that this is a simple matter of trying to sever Sidney Powell and Kenneth Chesebro's case from the rest of the other defendants. But, you know, something that black and white thinking, that groupthink that is sprung out of that authoritarianism, that sort of dictatorship, monarchy, communist type space, you know, coming historically from where fascism is sprung up, is black and white thinking. I can only think this way. But at the same time, an undercurrent of that is the rules apply to thee, but not to me. You know, do as I say, not as I do. So while there are rules that basically authoritarianists want to push very, very aggressively, at the same time, they are not following those rules themselves. Beyond that, there is just an inherent meanness, lack of respect, lack of compassion, and aggression that is egregious, you know. And just if you go and think back, no matter what your race is, no matter your religion, no matter your ethnic background, but if you think back to the past 7 years, you will think back to the fact that America has seemingly become quite mean. And I know that just sounds like, you know, that's not the concern here, but just think about it. You know, like, even while looking at this case, which again makes me want to barf up my dinner, the fact that we even have to be looking at this right now, the fact that we have to even be observing this, it points to where we are as a country. It points to the fact that this should have come up a long time ago. But at the same time, this authoritarianism that sprung up was so slow burning. And at the same time, these people have a smile on their face. You know how someone has a smile on their face, but they are so threatening. And that's what the narcissist, honestly, this all has narcissism, rugged individualism, anti-black sentiment, othering, white supremacy, has all of that wrapped up in it. And sometimes it'll have a smile, but what they're saying is so dang on threatening that it's not even funny. So I want you really to pay attention to mannerisms and tones. Again, I'm not a lawyer, but I do have half a brain. I got to speak out about this. As a woman, as a person of color, as an American, you know, as someone in an interracial marriage, as someone who wants to go on and continue to have the luxuries that I've afforded being a part of a democracy and not see democracy be destroyed, I have to speak out on it. And all of us do. As someone who actually grew up in Georgia, I wanted to recommend you guys also to look at moveon.com. or moveon.org, one of those. I'm not completely sure that it's even 100% legitimate yet, and I still need to do a little bit more research. But what you can do on that website is you can sign your name up for a petition to keep Donald Trump off of your ballot for 2024. And I know that you can do that in the state of Georgia. I believe you can do it for any of the 50 U.S. states. Don't hold me to that. I still need to do a little bit more research. But in whatever way you can, if you want to protect the sanctity of American democracy and keep Donald Trump off of that ballot in 2024, do everything you can so that your state petitions to keep him off of that ballot. Again, keep in mind that justice is coming underway. Keep in mind tone. keep in mind the fact that the defense don't talk about the bigger question at hand. They don't talk about the bigger question at hand, that democracy was attempted to be overthrown, that racism, autocracy, fascism, xenophobia, hate crimes have all been on the uprise over the past 7 years since Donald Trump and his cronies have come into power. They don't talk about that. They don't talk about the victims. They don't talk about the victims in a way that is emotionally intelligent, that says, hey, these people have been through a whole lot. We want to be there for that. I want you to look at the way they make eye contact. I want you to look at their tone, okay? And I want you to be brave and speak out against this. Not only in the way that you speak to your friends, your family, across your social media channels, etc., and keep Donald Trump, all of MAGA, out of power, okay? Because if that increases, we lose American democracy. I also want you to vote, okay? Be proactive and vote blue in 2024 on all levels of the Congress and the executive leadership, Supreme Court. And with that being said, let's take a look at this.
Thank you. Please be seated. All right, we are back with 23 SC 188947. Mr. Grubman, have you received express permission from your client to waive his presence?
Good morning, Your Honor. Yes, we have.
All right, Mr. Rafferty.
Yes, Your Honor. Good morning.
Good morning. So we have 3 motions teed up for this morning, and why don't we dive right in? Beginning with the motion to speak with the grand jurors, joined by Ms. Powell.
Judge, just as a preliminary matter, the state intends to comply with all of its legal and ethical obligations to turn over the co-conspirator information with just the understanding that the reason why the names of the co-defendants are not already in the indictment, Judge, is that courts have frowned upon putting the individuals' names if they're not charged within the charging document. We'll turn those over to the court with a request that the court hold them under a protective order, so to speak, to protect the identities of those individuals, or to control, I guess, the public impact of the names that are on that list.
All right, so it sounds like you want to skip to number 3, the motion to disclose the co-conspirators?
Well, just to do away with.
Right.
Kind of streamline it.
All right, let's start with that one. It might be the easiest to get into. So let me make sure I'm understanding what I'm hearing. So you're wanting to, you are willing to go ahead and just give this list to the defense counsel?
Yes,
informally through the discovery process?
I'd like to present it to the court.
Okay.
The court can then distribute it to defense counsel as it sees fit, but it's the state's position that because the practice of naming the co-defendant, the unindicted co-defendants or co-conspirators in the indictment has been criticized, the state is elected to do it this way in order to protect those individuals and those names that are on this list. So
I'm tracking you completely there, and I agree. I think that's the standard practice. I'm curious why I would be the middleman. It seems like we could take the folder and just give it right to the defendants. I think that would be the regular thing to do.
Well, I mean, the court could impose a protective order that all of the parties to this case are subject to about disclosure of discovery to the media, if that is the concern of the government. But we have a trial on October 23rd. They have the list of co-conspirators. They're consenting to the motion. Why don't they just give us that information directly?
Sure, I think we're all about to reach the same place. So the bottom line is it seems like this is a fairly straightforward request. I think federally it would be a bill of particulars, and those are fairly routinely approved. So I can file an order if you want me to, but otherwise we'll say that the list of individuals 1 through 30 is going to be disclosed to not only, I would think, these 2 defendants, but the other 17 defendants through the discovery process and obviously right now. So in terms of a protective order, if the state's requesting one and the defense is not objecting, we can certainly do that as well. But otherwise, it seems like this is just a fairly routine part of the discovery.
Okay, guys, so really quickly before we move on, I just want to note that we are looking at what looks like evil villains from a Disney cartoon. Really. We've got cowboy boots. We've got face stuck like that. And then we've got overdosed on testosterone. That is defense. Okay, I concede. The next thing that I want to say is, you see here from the Fulton County prosecutors, they actually care about the safety of these people involved. You know, they don't want to just be disclosing everything willy-nilly because people get threats. You have seen over the past 7 years that whole side of MAGA become so violent. You know, okay, being in the public eye comes with a certain amount of vulnerability. We get that. But you guys think back to a time when people weren't receiving threats of their safety, threats to their children, every 2 seconds. Yeah, okay. Yeah. Beyond that, I want to make it clear here, to my understanding, again, I'm not a lawyer, I don't understand everything. But to my understanding, even the state prosecutor's side hadn't even reached the deadline yet where they were supposed to turn this information over, okay? They hadn't even reached the deadline yet, and these people are basically hyperventilating. The last thing I want to say, and let's keep going, we are going to need deep healing after all of this is done. After autocracy is crushed, America's going to need some deep healing with mental health, deep look at mental health.
Care of, but the motion goes a bit further than that, Mr. Wade, and says that they want to be able to inspect the entire transcript, assuming there was one, I don't know,
Let's keep going.
and any recordings and essentially anything that the special grand jury produced. So let me just let me get your, obviously I'll let the defense present their motion, but let me first start with where the state is in terms of what you think of that is disclosable and discoverable. If the state's following its standard open file policy, just maybe give me a bit of background about that and what you think is fair game here.
Yes, sir. Basically, Judge, the state would contend that any transcripts, any and all transcripts that have been produced by the grand jury or the special purpose grand jury are not discoverable, and that the defense counsel should not have access to them. And I know that the court wants to hear further argument on that after the defense has this opportunity to put their case on, but that's our position.
With the sole exception being Mr. Cheely's?
Given
Okay.
that Mr. Cheely is directly charged in count 41 of the indictment, that's the exception.
And what if some of these witnesses that testified you call as a witness at trial?
So, Judge, then we rely on actually the discovery statute. It talks about that. We would say that at that point, when the state has made the decision to call one of the witnesses that has testified before the grand jury, at that point, the transcript becomes relevant and you turn it over.
All right, so we may have to talk some logistics, but we'll see where we end up. So, Mr. Grubman or Mr. Aurora, your motion.
Your Honor, I would just take exception with doing what they call Jenks material in federal court, where they give it to you at the last second, because we have to craft a defense based on what people
And then
are saying.
that's what I was getting to. We'll get
So,
there.
if we look at the litigation that happened before the special grand jury, it's 2022-EX-00024. I'd like to adopt the brief that was filed by the media companies asking for the release of all these transcripts, because they've got a lot of the law that I've cited, so we don't have to sort of go through all of it. OCGA 15-12-101 lists out the requirements that a special grand jury needs to do, and that requirement includes interim reports that have to be presented to the judge as far as what their work is going on. I didn't know if there were transcripts, but apparently there are in this case, as what the prosecution says. We know that based on the report that was released, there were 75 witnesses that testified before the grand jury, which I'm imagining were all recorded. They've already told this court they're going to have 150 witnesses, so whether they choose to call those witnesses or not, I'm entitled to those transcripts to decide if we want to call them, if there's any impeachment material out there, inconsistent statements, or, in fact, exculpatory material that might have been said by any of these people. So I think we have an absolute right under the discovery statute. They have to present all the information from their case in chief to us, as ordered by your scheduling order, and there's no protection that's out there. We then go to 15-12-80 that gives you the criteria for publishing the special grand jury report. I've also cited the cases that talk about the secrecy issue sort of goes away, hence I think the foreperson of the special grand jury went to the press and made all kinds of statements about these issues. Olson versus State is probably the seminal case. It's 302 Georgia 288 2017 case. And then I also cited the In re Gwinnett County special grand jury case that also allowed for disclosure and said the secrecy doesn't apply after they finish. That cite is in my brief as well, Your Honor. I would further go back about 70 years and go to Dennis versus United States in the United States Supreme Court, 86 Supreme Court 1840. It's a 1966 case that also talks about requirements for disclosure for grand jury transcripts. In every federal case, grand jury transcripts are made available to the defense. They just have a different statute as to when that Jenks material has to be released.
But it's not every transcript. It's simply going to be the witness that's called.
The
to
witness
testify,
transcripts.
Right? You're asking for everything.
Well, I don't know what exactly they...
Right there. So I have warmly nicknamed Mr. Aurora Face Stuck Like That because I think his face is stuck like that. Even the judge pops in right there is like, you don't need all of these transcripts now. Now, let me also just make it clear to you. Narcissists, people who want to run a dictatorship, people who are so insecure in their abilities. And remember, this is coming from the top down, okay? This isn't just about Mr. Grubman, Mr. Aurora, Sidney Powell, Kenneth Chesebro. This is coming from the top. The one who has 90-something odd indictments against him and tried to overthrow the U.S. government is coming from the top down. And he has the same the defense has the exact same tactics as that person all the way at the top. Do as I say, not as I do. The rules apply to thee, but not to me. White supremacy, racism, xenophobia, anti-black sentiment, othering, aggression, authoritarianism, all blanketed under the guise of politeness. And let me just note, it's okay for Mr. Aurora to cite and quote his cases, but when the other guy gets up on the state side, they get up and they present their PowerPoint, which I think it's within their legal rights to do a PowerPoint. They get knocked down. I just want to also note that there was a time where state prosecutors were respected and the law process was respected. Yeah, they want everything, huh? They want everything because they want to exploit it.
Much lower as far as that goes once the special grand jury is ruled.
They want to exploit it for personal
made
gain,
the recommendation.
like they've been doing for 7 years.
Okay.
That's all.
Thank you, Mr. Aurora. Mr. Rafferty, I think you joined this one, did you not?
I did, Your Honor, and I would join in all the arguments that Mr. Aurora has made.
Well, actually, I think maybe you formally didn't on the record, but if you want to orally now,
I would
that's
join,
fine.
Your Honor,
Okay.
and the only thing I would add and echo from Mr. Aurora are the due process concerns that he's raised. The government has said they'll turn them over, but only turn them over after they call witnesses. That smacks of gamesmanship, and it would not be the efficient way to try this case. There is no real reason for the government, they have to disclose their witnesses, to not disclose the transcripts of any witnesses that testify before that special purpose grand jury that is going to testify at the trial. Moreover, and I'll raise this at a later point in this hearing today, I do have some very grave concerns about the government's compliance with their Brady obligations. I have already submitted 2 Brady requests. I have not gotten even a response. I'd like the opportunity to raise that later, but I believe that there could be Brady information that is in those transcripts that they are obligated to turn over independent of any statutory discovery obligations.
All right, Mr. Wade.
Yes, sir. Judge, I think we have started to put the cart before the horse, so to speak. Let's start with the premise that long-standing and unquestionable authority indicates that grand jury materials, including transcripts and records,
We didn't put the
are
dang
not
on cart
available
before the horse.
to criminal defendants because grand jury proceedings are considered to be confidential, and the state is relying upon Stinsky v. State there. And I have copy here for the court. And counsel, if I might approach, Judge.
Thank you.
So this Stinsky case, along with the Ruffin and the Isaac case, Judge, stands for the very same proposition, which is they're not. Let's go.
Do you think there's any distinction here between these cases that are going to talk about grand jury proceedings and this having been a special grand jury that they're asking for?
There's no distinction there.
And why not?
Well, for practical purposes, Judge, it's the same function with the exception of the charging element. The special purpose grand jury is an investigative tool. Investigative jury does not make charging decisions, but can make recommendations. A regular grand jury obviously passes down the.
Okay, let's talk about this for a moment. Now, first of all, I do not know what a Grady defense is. Again, I'm not a lawyer. I'm just an average person who does not want to see American democracy crash and burn. We got to speak out against this, guys. I know that for 7 years, many of us have held our tongues because these people are threatening. They come with the guise of professionalism, even maybe politeness, sometimes not really politeness, but they are aggressive. The way I want to highlight this for you, anti-black stuff all over this, white supremacy, othering, sort of belittling, this inferiorizing nature of the defense. Just take a look at the way that eye contact is coming from Slytherin over here to Gryffindor. Just take a look at the eye contact. There is hate in those eyes. When Mr. Wade gets up, when he walks over, when he talks, when he smiles, when he frowns, when he grimaces, anything he does, there is eye contact that is hate-filled. But I notice that when he walks over to the defense's table, certain people in the defense's table don't make eye contact with him at that moment. But when he is up on the stand talking, when he's talking to another individual, there is a very sharp stare at it, and it is aggressive. I feel like every single black person has felt this at some point before, especially in the last 7 years, where someone is sending you a stare of hate. Not just black people. You could be Hispanic, you could be Asian, anybody who basically is not a white man. You have felt that before. I know exactly, you know what I'm talking about. It's time to get that sentiment on up out of America. It doesn't belong there.
To
okay?
point, direct the court's attention to
that's the first thing.
the fact
These
that
are
there's no
clearly
authority that
professionals on the
demonstrates any
state
defendant
side.
is entitled to these grand jury transcripts. Courts disfavor the release of these transcripts. Defense has pointed to no overriding factor that would override the policy favoring the secrecy of grand juries, and that is the guiding principle, Judge. It's the secrecy of the grand jury. The Supreme Court says that the grand jury is a public institution serving the community that might suffer if those testifying today knew that the secrecy of their testimony would be lifted tomorrow. This indispensable secrecy of grand jury proceedings must not be broken except where there is a compelling necessity. They have to show what that compelling necessity is, Judge. And the Kessler case, along with the other cases that the state has just given, support that proposition. But also, the Supreme Court in the Anderson case does as well. Now let's talk about the Supreme Court, because they've identified five factors, Judge, that are present in the Douglas Oil case that
I'm taking my notes, y'all.
First, if the pre-indictment proceedings were made public, many prospective witnesses would be hesitant to come forward and voluntarily, knowingly, and those against whom they testify will be aware of their testimony. That's the first thing. The second factor against releasing the information is witnesses who appear before the grand jury will be less likely to testify fully and frankly, as they will be open to retribution and also to inducements, which we've seen a little bit of in this case. Third, there also would be the risk that those about to be indicted would flee, or fourth, would try to influence individual grand jurors to vote against indictment. 5, and finally, by preserving the secrecy of the proceedings, we assume the persons who are accused but exonerated by the grand jury will not be held up to public ridicule. Those are factors, Judge, that the court should consider in determining whether or not the grand jury secrecy provision has been overridden by counsel's arguments. We don't believe, Judge, that the defense has relied on any case that would override those factors, but moreover, any treatise that would assist upon them in their reliance, Judge. They did cite to the Henry Gwinnett County case, Judge, and even in that case, the requirement that secrecy be maintained among all types of grand juries without distinction. And that's in the Henry, and I'll report a copy of that case. I apologize, Judge. I didn't bring the court a copy of that Henry Gwinnett County grand jury case, but that's the case that counsel relied upon and cited in its brief and even in its argument today. But that case is found at 284 Georgia 510, and it stands for the proposition that the requirement that secrecy be maintained among all types. It says all types of grand juries without distinction. So again, the state would submit to the court that there's no difference.
Go, brother.
All right. So obviously I'll take a closer look at all the cases you've given me, and I think just as an initial reaction, you're probably right when it goes to saying everything should be turned over. But I want to drill down a little bit more on the witnesses who maybe at this point already you know that you're going to call in November, right? I think that's the whole point of our scheduling order here, and what we try to do is that we need to use our trial days efficiently and use our jurors' time efficiently. And I would imagine that the state is going to have an order of proof going into this trial with a list of witnesses. And if there are witnesses that are on there, the idea of waiting until the minute before they're called, and then we've got to now pause the trial for an hour or two while then they're reading the transcript, I don't think we can do that. Would you agree?
I agree, and I understand that, Judge. The state wasn't intended to convey that it would hold on to a particular witness's transcript until the eve of trial. We're still obviously going through receiving the transcripts, Judge. We don't even have every one of the transcripts. And so we're still going through that process as well. But I don't think that the court has made an unreasonable suggestion that the state not essentially implied that the state would not hold on to the transcripts until the 11th hour. That's not our plan, and that's not how we plan.
So I would think at a bare minimum, and maybe we can talk about whether we have to move that timeline at all, but your witness list is going to be due 10 days beforehand.
Yes, sir.
And so in conjunction with that, I would think that any witness on there who has a transcript, that needs to be either expedited or rushed and also provided at that same time. And if the issue comes up that, well, we didn't put a witness on that 10-day list, but now we think we need to call them, unless it's for a rebuttal or some new issue that's come up during trial. I'm going to be looking at that and really wondering if a good faith effort has been made to turn everything over. So I think that's not only what defense counsel was referring to, but I think that's what we have to do to proceed efficiently at trial.
Yes, sir. Yes, sir. And there's no argument or disagreement. I think that the court is being reasonable there. But while we're talking about that discovery, we believe that we're still in line with the court's scheduling order as it relates to discovery. So, counsel standing.
Yeah, well, and we'll talk about that at the end. Let's get through the motions first, and we can get more into discovery. But generally, I would think this case is obviously different, but the state's open file policy traditionally has been, here's everything we have, unless there's some kind of state secret or a confidential informant or something along those lines.
Yes, sir.
And you have everything that we have, and here we go.
Yes, sir.
So I don't know if that's going to be the spirit that we proceed with here. It might streamline things somewhat, and we'll see where it goes. Any thoughts or reactions to that?
Oh, it is the spirit, Judge. The district attorney has been clear in our instruction. We are to make information available to them as it becomes available to us. We are here prepared today to turn over portions of the discovery to the two defendants that are going to proceed with trial on the 23rd. Obviously, we plan to supplement that discovery as we go along and as we receive the information, but we've made a good faith effort in complying and being reasonable and working with defense counsel, and we'll continue to do that.
All right. And when it comes to supplementing it, I would think that's going to be confined to new discovery.
Yes, sir.
Stuff you don't have right now, right?
That's stuff we don't have right now. Yes.
So I think for purposes of the motion, let's see, to unseal, I'll take it under advisement as it concerns the entirety of the record or anything that happened there. But as an initial thought, at a minimum, it's going to be granted in part as to any witnesses the state plans to disclose.
Yes, sir.
All right. Anything else, Mr. Rafferty?
A couple comments I want
Sure.
to make in response to the argument.
So really quickly, again, I'm not a lawyer here, but I just want to note that I understand what's going on here. There's got to be a little bit of discretion on what the state shares with the defense of Sidney Powell and Kenneth Chesebro, and when they have it, when they do, because this is different. Okay, it's just like the fact that Democrats right now have to be very cognizant that we're not competing on the same levels with the Republicans, the Republican Party of today, of 2023. Because the Republican Party of 2023 is not playing the same game that Democrats are. They are playing some shisty thing where it's like, scruples, ethics, morals don't have a chance. These are real people who are scared. These are real people who are scared that they could be threatened, that their children and their families could be threatened. And you don't ever hear the defense talk about that. The fact that you don't hear them talk about that real people have real lives and that they could be threatened, I think that should tell you where they are. Now, I wanted to say that as an average American person, I want to echo the sentiment that I'm hearing from other average American people, that we are disappointed in the slowness of the legal system. We've been going through this for 7 years. 7 years. I understand that there is a certain due process that needs to come to people, but there's no reason that Donald Trump and his cronies really need to be showing advantage of the law right now. This autocratic criminal enterprise, the Trump criminal enterprise, needs to be shut down immediately. And I hope that no law enforcement, judicial system, prosecutor, anybody pussyfoot on this, because this is not something that needs to be pussyfooted on. We're in a battle right now to protect American democracy, no matter what kind of hyperventilating testosterone bag or sack that you've got in front of you. We're battling for American democracy. The people who don't talk about the victims in all of this, those are the people to be wary of. Now, again, I'm highlighting the tone. Just while Mr. Wade is speaking, there is a visceral hate coming towards him. If you'll notice, and again, I want to re-clarify this, restate this again. Any person of color, any LGBTQ person who has lived in the United States of America in the last 7 years knows that visceral hate. Just that hate that's sitting there, watching your every move. That is predatorial. Okay? That is territorial and predatory. That is aggressive. That is stalking, watching your every single move. I guarantee you every person of color, every LGBTQ person understands that. And if you're going to deny that you understand that, you are the exception. You are not the normality, at least not over the past 7 years in the United States. And I'll argue that that bleeds over even out of minority groups. That bleeds over into every single person who does not kiss the orange elephant's butt. Now, I just wrote these notes down, guys. I want to say this. I hope that this judge does us right. With all that being said, that democracy, okay, I know that we're focusing on these little micro parts of how this all fits together with January 6th, with the big lie, you know, with the air of hate crimes and xenophobia, rising crimes, rising racketeering, rising fraud, rising bad behavior over the past 7 years. I know that this is a micro piece, but we got to keep remembering the macro. And I really, really challenge the judge. I challenge all of the state prosecutors, and I challenge every single American to remember that. I hope that this judge does us right. I think that he will, but I really just want to reiterate, I hope that he remembers that these people tried to play us. They not only tried to play Georgians, they tried to play every American person. So with that being said, these people are charlatans. These people are autocrats, they are charlatans, and they are authoritarian criminals. And any courtesies should not be given. Mandatories should be given. Courtesies should not be given because they're just going to exploit them. So don't disclose the transcripts any more than necessary. That's my thought.
Mr. Wade, he cited to a Supreme Court case, Douglas Oil versus Petrol Stops Northwest, a Supreme Court case. It cites to Rule 6E of the Federal Rules of Criminal Procedure. The problem with that case, Your Honor, and the case he cited is it has to do with the use of grand jury transcripts in a civil proceeding, which I know Your Honor knows, grand jury transcripts in the federal courts.
This man needs to do some mindful meditation.
Criminal investigation can't just
you
be
need
turned
some yoga,
over in
buddy.
civil cases. And so the case he cites has to do with whether or not and under what circumstances grand jury transcripts from a criminal investigation that results in an indictment can be used by civil practitioners in a civil case. That has nothing to do with this case. And the point I'm making with this, Your Honor, is this. The government has now cited to a case that really has nothing to do with this. They come to court here today. They don't respond to the motions in writing. They drop some motions on defense counsel, or some cases, I should say. They don't put anything in writing. And they just say things to Your Honor. And that's a troubling practice for me as somebody who practices mostly in federal court.
Oh, it's troubling, huh?
This is a serious case.
I think you have to realize, I think that might be the standard practice in this building.
Oh.
I understand that, Your Honor.
Thank
but I
you,
look
Judge.
behind me and I see
Thank you.
eight folks here on the government side. We're talking about a case
He can
that
keep
is
railroading.
unique, to
He
say the
didn't hear
least,
anything the judge just
involving allegations related to the supremacy clause, First Amendment rights, all kinds of things. Defense counsel are writing motions. I think we're at least entitled to a written response from the government citing these cases so that we have an opportunity to inspect them. Because otherwise, what happens is the government comes in, cites to a case that has no application whatsoever, and suggests to Your Honor that it is precedent that governs the disclosure of grand jury transcripts when it does not. And so my concern and my request is that, and I filed a motion last night where I specifically asked the court to order the government to respond in writing so that we have a chance to look at these cases before we come to court here today. That's my request.
So, Mr. Rafferty, I think that obviously some of this going back and forth will be touch and go, but I think what we could easily do today and going forward as well, not every motion may require that, but we can always say if a party wants post-hearing briefing, we'll do that. I'm not intending to rule from the bench on a lot of these complicated issues. I mean, I handed a stack of cases and I'm going to read them. and we're going to have time to get through it. It's going to be an expedited timeline, but I'm certainly going to give you the opportunity to respond.
I appreciate that, Your Honor, but I guess my point is, and I think my counsel here would join me in that, this process would go a lot quicker if the district attorney's office with their team of lawyers would write a brief that cites to the same cases that they're bringing to court every day so that we have an opportunity.
Okay, so this right here, hyperventilating testosterone, that's the nickname I've given him. Like, you feel that energy of anxiety even before he takes the stand. You feel bubbling aggression, hate, anger over on that side before he even gets up. You feel where that's at. You feel superiority. You feel all of that stuff, right? Again, they're not respecting the attention to safety and security of the victims here. It's just like, give me what I want. Give it to me now. Give me what I want. Give it to me now. Where's the respect for the due process of the law? Where's the respect for the victims? Okay? Sidney Powell and Kenneth Chesebro are large parts of this, but they also are just one puzzle piece in a huge puzzle. Let the law and due process play out. And I'm going to get into this a little bit more, but let me just go ahead and say real quick, not only have they been watching with hateful, spiteful eyes, but even what you guys notice, even when the judge tells him, of course, we're going to give you that time. Of course, we're going to give you the materials and the time seen fit. The judge doesn't even acknowledge all of his inflated attacks towards the state prosecutor, saying that, they have repeatedly been insubordinate, essentially. They have repeatedly been insubordinate. Anybody who's ever says that, like something's off. Oh, you've repeatedly, when that's not been the case. You repeatedly, he's basically saying, listen to me, I know everything, I am the know-all, I am the end-all and be-all. That's the air that he's given. The judge doesn't even really acknowledge that. He knows the state prosecution team is doing their best. He knows they're doing their best, and he knows that they're doing things the way that it should be done. But even when the judge says, I hear you, like, we're going to work with you, that doesn't stop him.
Before we come before Your Honor to look at those cases and question whether or not what those cases say supports what they're claiming. And if they don't, be prepared to address it so that we can move this along.
Threatening.
As opposed to us
be
having to go back after today, research the cases, then write a post-hearing brief, point out to the judge that what the government is saying is not actually true. So that is one of the benefits, respectfully, Your Honor, of requiring the government to put it in writing.
All right, understood.
Just briefly, in response to Mr. Rafferty's argument, he did, in fact, we would say at the 11th hour, file a motion requesting that the state respond in writing. The state has done that. I don't know if Mr. Rafferty has had the opportunity to check his filings, but the state has done that this morning.
Is this for this particular motion?
It is,
okay. And obviously, I think we're also, one of the logistical challenges we're dealing with the case is that you e-file something and it's taking hours for it to post the docket. So we're just going to have to recognize that, and I think that's why I would say emailing a courtesy copy is going to be the way to go.
Yes, sir. So this morning the state has filed it. It does cite to and speak about the cases that the state has cited to this morning and provided copies of.
All right. So, Mr. Rafferty, Mr. Rohr, obviously you want a chance to respond to this and review it. So we're not ruling on this today, and we can take the time to allow you to do that.
Just perfect the record on a couple of things with the special grand jury, if that's okay.
Sure.
Come on, face stuff like that.
So again, I'm citing back to Judge McBurney's order as well as the issues on the special grand jury case. And when you look at 15-1280, they specifically said it's different from a regular grand jury because they make recommendations as to should we release this report or not release the report, and they vote on it, and there's all kinds of discrepancies that aren't the same as a criminal grand jury, which is what we've got here. Now, I take exception to the courts. I know you made a comment that if they're going to call a witness, they have to turn it over in a certain time. I get it. What about all the other witnesses they don't plan on calling? They may be witnesses for me. 1716.4 should trump all that because that's the discovery statute that says any witness that they've talked to has made a written statement has to be turned over. That's where the due process is. They don't get to pick and choose what witnesses we get to see or not see. I might want some of them. And if we wait, I guess your order says disclose everything by the 20th of September, so I'm assuming we'll get a big batch of discovery. I've been told up to 8 terabytes by the 20th. I need to be able to review it so I figure out what my defense necessarily is going to be versus doing it on the fly like we do in federal court. And we don't have trial by ambush. That's why I appreciate we're here and the discovery statutes are strong. So that's my point to you. And I would also go ahead and cite to Olson again, which is the most recent case that specifically says, notably, the oath of secrecy no longer extends to the state's attorney, and even the grand juror's oath encompasses only deliberations and not all things occurring in the grand jury room. So at least for the special grand jury part, aside from the second brief that we've got, we should be able to get everything that happens in there aside from arguably deliberations, but at a minimum, at least the 75 witnesses or whatever else that they presented. So I would say that Your Honor said at least what they're going to use. I think that's not correct enough. It should be everything. Thank you.
All right. Like I said.
Okay, what we're going to see next literally makes me want to barf. Everything from the defense's side is not, it's a type of decorum that I've never seen in my 32 years of life ever in a courtroom. Ever, you know, like the only place that I've seen this is in the MAGA circle, in the MAGA circus. Again, just noting the condescension, the evil eyes, the sort of attack at competence, you know, the attack at the competence of the state prosecutor's office of a county that is majorly black. You know, just I have to point out that anti-black sentiment. I have to point out just the lack of decorum, truly. It's like the lack of respect for the judge, the lack of respect for the prosecutor, and the lack of respect for the victims. This is something that we have to keep driving home and not forget about, is the victims. You know, I haven't heard, maybe I missed it, but I haven't heard one single time, and this is the second time we've watched one of these trials together. If you haven't looked at it yet, look at my review of the first one. Again, I'm not a lawyer, just an everyday average person, but everyday average people, we got to speak out against this. For 7 years, we didn't speak out against it because we were scared. We didn't know that's what it was, because these people are aggressive. They act like they are the moral authority. They act like they are within the right. They act like they're within their means. So I understand that many of you didn't say anything at some point, you know, because you were scared. You didn't understand that we were coming under autocratic type rule, or at least wannabe autocratic rule. But, yeah. Just look at this next piece and you'll really understand who these people are. They basically are saying, make it really easy for us to continue to corrupt, cajole, and threaten. That's basically what they're saying. No, there are real victims in this, man. It's time for us to be done with this. Intimidating.
Colin, that really predates it.
Yes, Your Honor.
And in Colin, they've got the defense calling a grand jury witness to talk through some of these issues of who can be present during deliberations, who can be present during the presentation of evidence. And so it seems to me that I agree with you that you have a right to talk to grand jury witnesses. What about? We'll get to. And I'll say it on the front end, I appreciate you filing it this way because these grand jurors have been through a lot.
Yes.
And I think we need to recognize that and craft a remedy here that recognizes that.
You heard that?
So my initial reaction, just to lay it out there, is that, yes, I think you have the right to speak with grand jurors. How that happens, I think we can discuss or craft. I think maybe, I don't even know if you can have their contact information. I've heard that it maybe already be out there, but I think that might have to be something that is facilitated in hand with the state. It also has to be something that's voluntary on their part. But then the question turns to what end are we doing it? And I think that, as you alluded to, if the inquiry is to determine did they act independently, all right. But the standard you're laying out here that they have to, where I then start, drawing, kind of pausing, is this standard or this benchmark that they have to have affirmatively read every word of the indictment. And that's where I wonder if this might not be there might not be a point in going down that road. If you have some other reason you want to explore, then so be it. But this idea that we have to show.
That's an example, Your Honor. First,
Okay.
I wouldn't necessarily say every word, and if I did say that, I apologize. But what I do think we would have a valid argument on, and obviously at the right time the court would, is that if it was simply summarized, Your Honor, please understand, and I hope everyone understands, all the information that we have is the stuff that these folks print in their papers. We don't know. So I am not saying that that's what happened in this case.
Well,
I will say I have suspicions.
Let's even play in that sandbox a little bit. Let's say it was just summarized, and again, we're just previewing the arguments to see if this is even worth getting into later. At trial, a jury could come back with a 15-minute verdict, and there'd have been no way that they could have read a lengthy indictment or even looked at every exhibit, and there's no inspection or remedy for that. So why would the grand jury, where would this rule come from?
Well, it's not like there's a rule in the statutes, but what there is there's a rule, there's a theme in the case law, and we cite many cases, and I'm sure we could cite a lot of other cases, that the grand jury must be independent. Now, what is that? That's why I start with asking, what did that mean? Does it mean that they have to read every single word? I don't know, Your Honor. And if that issue comes before the court, we will brief that issue and we'll figure it out. However, I would argue that if the state of Georgia, in this particular case, presented their case to the grand jury in one day, which I can't say for sure, but based on the publicly available information, that's a possibility. It would cause my eyebrows to go up a lot.
A lot
And
causes
I'm
your
not alone.
eyebrows to go up.
Judge Choflat in the United States v. Sigma International, now that case has been vacated. It's not presidential. Yeah, that's the right word. But that being said, the dicta still applies.
But that case didn't have so much to do
All right,
with
cowboy boot.
any method of how the jurors reviewed the indictment.
All
I
right,
think they were
cowboy.
citing the transcript of the AUSA, essentially steering them exactly where to go.
Well, Your Honor, the thing is, that may have happened here. I don't know.
And I hear you there. Just my point being is that just summarizing an indictment to me, for example, if we know the deliberations, we can't go into that. That's protected. How would you ever ask the question of whether another grand juror read the indictment to everybody else during deliberations? I don't even think you're going to be able to answer your own question.
I respectfully disagree, Your Honor, and we could craft some questions. Obviously, we would have to think of the language, but what I think we want to know is, Mr. or Mrs. Grand Juror, when the evidence was being presented to you, did you have the opportunity to ask questions? Did you have the opportunity to follow up? Judge Choflat said, and this is dicta, but we rely on dicta all the time as at least persuasive. So too, would we dismiss an indictment that was issued by a kangaroo grand jury, quote unquote, one whose deliberations were so overborne by a prosecutor or judge that the indictment was in effect the prosecutor or judge's handiwork and not the result of considered judgment by an independently functioning grand jury. Now, while we can't ask the grand jurors what exactly happened in the deliberations, what I think we absolutely can ask, and we will ask, I will put this on the record, is was there anyone other than the grand jurors in the deliberations? And that, I think, is what the other case that we cite, Collins, stands for the proposition. But, Your Honor, we simply want information. The reason we filed this brief, this motion, is to be above board and make sure that everything was out there in the open. However, I would respectfully push back, Your Honor. We would not agree, obviously, court could order anything they want, for any member of the prosecution to be part of those conversations. We are officers of the court. We know the rules. We will follow the orders. I would also ask the court to state, or I would ask the prosecution to state on the record and commit. I'm not saying that they're going to do this, but I have seen other prosecutors do this, that if the court grants this motion, they will not attempt to influence the grand juror's decision of whether or not they talk to us. We, of course, know it's voluntary. We would never, once the grand juror said, I don't want to talk to you, we're going to hang up. I could promise you that, whether it's us or our representative. But I think there's a risk here that someone from the state might try to get to them first, and that would be inappropriate.
What if the grand juror wants a prosecutor to just be on the call listening as well?
If the grand juror wants a prosecutor to be on the call, then, if they proactively say that, we can see.
Yeah, because they know that the prosecutors will actually protect them.
They're not inviting us. I've never got an invitation to help them draft the motion or to talk to them, sit in their conference room, and they don't have the right to be with us. If they want to talk to the grand jurors, they've always been able to talk to the grand jurors. They have talked to the grand jurors. But I like Mr. Wade a lot, but I don't want him on that phone call because he's my adversary. And quite frankly, I think that think about this, Your Honor, if hypothetically there was something that happened in the grand jury that wasn't appropriate, the fact that a member of the prosecution was on this call, I think, would prevent or at least make it less likely that a grand juror would be honest with us. What if a grand juror felt, and I'm not saying this is true, but what if a grand juror felt that they were bullied by the state into prosecuting?
That's
what if
your
a grand
game.
juror
That's
felt
not the
that
state's game.
the state, went a little overboard? Well, if Mr. Wade was on the phone, I don't think they're going to admit that to me. So as an officer of the court, Your Honor, I think the court, with all due respect, just needs to be able to trust counsel that we will do the right thing, and I could commit 100% that we will. These grand jurors, you're absolutely right, have been through a lot. They sacrificed a lot. We are not that, there's been doxing and all sorts of things. We are professionals. We are not those people.
How would you be planning to document this in some way? Or would you be recording these calls?
Yes.
Would you have a court reporter? What would be the plan?
I believe there would be so we haven't talked exactly about the logistics, but there would be some sort of recording, whether it's a court reporter, just a good old, iPhone recorder or whatever it is. And we would tell the grand jurors that, even though you're not required to do so in the state of Georgia, I would be much inclined to tell the grand jurors, hey, look, we're recording this. It's, just so there's no question of what was asked. Obviously, Judge, the last thing I want to happen is for anyone to incorrectly accuse me or someone on my team of going past what we're allowed to ask. So for my own sake, we'll definitely have some sort of recording. Unlike the state of Georgia, as Mr. Rafferty said, they have about 15 lawyers, a bunch of investigators, and basically an unlimited budget paid for by the good taxpayers of Fulton County, myself included. We don't. I want to be clear, despite what the media may have said, we don't have an unlimited budget. So whether we could ask a court reporter to be there, unless the court would volunteer your court reporter, I don't know that we can afford that, quite frankly, but we will certainly record it.
All right, so essentially what I'm hearing is what you'd be asking before is that we'd propose if not the exact questions, but the subject matter, very carefully phrased in advance. This would be a voluntary meeting. It would be documented in some way, and even if the state is not on the call, I think that we could also have someone from the court there as well, just at any point,
yes,
if the juror feels like they need to kind of pull the ripcord.
Yes, Your Honor.
All right, but otherwise, I don't think there's much point going into the merits of the motion because that's just a bit premature. So that's the initial reaction, Mr. Wade. Or sorry, Mr. Rafferty, you had joined this one. Excuse me.
I did join the motion, Your Honor. The only other point I would make, I joined Mr. Rubin's arguments, is the possibility that these interviews not be conducted by phone at all. Perhaps they can be conducted in person, and there could be accommodations made, I would think, with the state and with the defense, conduct these in person as opposed to over the phone. That's just my opinion.
And I think, in me, the driving consideration is going to be the desire of the grand juror. Do they want to come all the way back down here and deal with that, or would they rather just do it over the phone? All right, Mr. Wade.
Just let me be clear. This
All right.
is absolutely
So, guys,
opposed to
real
any
quick,
place.
at least the state, Mr. Wade makes it clear that the state is opposed to that, and they should be, because Donald Trump and his adversaries, not his adversaries, but his allies, have clearly proven time and time again that they cannot be trusted with victims. This is something that's been clearly proven. It's why the judge said, yeah, put this in recording. And you see that Cowboy Boots basically is like, well, yeah, in the state of Georgia, technically, you shouldn't have to do that. But yeah, just for a goodwill effort. You see, some of that aggression. I want to highlight aggression. They're so aggressive. Some of that aggression is pointed at our white male judge, okay? but not as much. But you notice that aggression is way, way, way kicked up at the state prosecutors. Now, many of you might say that has nothing to do with race, but we should know better than that. There is anti-black sentiment wrapped all up in this, okay? This is America. Okay, this is America. Okay, this is the note that I wrote down. America does not trust that you will do the right thing. You know, Cowboy Boots kind of goes into, like, listen, like, you can trust me. I'll do the right thing. We understand that there's been doxing and that there's people that do that, but we won't do that. But if the track record proves anything, yeah, no, that's not the case. And I think that's even why the judge is like, yeah, maybe put somebody in the state's prosecutor's office to be there to observe what's going on. At least put somebody from the court in there. I think that right there says everything. As an average American person, when I'm looking at this, for me, the state prosecutor is representing the victims, i.e. the people of Georgia. Okay? When I look at the state prosecutors, I look at someone representing me as a Georgian, as an American. When I look at Sidney Powell and Kenneth Chesebro's lawyers, it's so obvious to me that they're not even arguing just for Kenneth Chesebro and Sidney Powell. They are arguing to maintain that power that MAGA has gotten a hold of, taking hold of Congress, taking hold of the Supreme Court, and trying with everything that they can to implant Donald Trump, a known seditionist, in the president's office. They are trying to hang on to that power with everything in their might. Something else I want to note. Aggression. Okay, coming back to that aggression. People get real aggressive when their money is at stake, okay? I know I can get aggressive when my money is at stake. Y'all heard Rihanna's song, okay? B better have my money, okay? People get aggressive when money is at stake. This isn't just Sidney Powell and Kenneth Chesebro's money who is at stake. Honey, this is the whole institution's money that's at stake. And the people are acting that way. I cannot get my glasses to not be crooked while I got these headphones on. Let me just take them off. It helps me to read. You can tell money is at stake here. The other note that I wrote down is that aggression is not normally the behavior of an innocent party. Go ahead and think about that for a second. Aggression is not normally but the behavior of someone who is not guilty. Aggression is usually the behavior of someone who is guilty, okay? And they are very, very aggressive. I don't know if it's in this part or the next part, but the judge speaks on it needs to be based on the desire of the grand jury. Okay, and I love that the judge points out that, hey, what if some of the grand jury wants to speak with the state prosecutors on the phone? That right there, if I was a person in the grand jury, I would be going to Fonnie Willis's office with every concern that I had. Never, ever with face stuck like that, cowboy boots, and hyperventilating testosterone. Never, never. Because I know that I would not be in the right hands. I would not be in the hands of someone who really cares about me. And maybe Cowboy Boots tried to stick a little bit in there. You know, he's the only one that I've actually heard try to stick a little bit of that compassion in there. I don't know that I fully buy it, but okay, sure. He even admit, like, dude, these are my adversaries. But, yeah, I would not be banking my money on these people who so clearly don't care about me. I would be banking my money on Fonnie Willis's office. I really, really would. So, and I think that the judge is clearly reiterating that as well. I don't think people trust y'all. Watch how aggressive this is, guys. On Fonnie Willis's office. I really, really would. So, and I think that the judge is clearly reiterating that as well. I don't think people trust y'all.
In terms of the
watch how aggressive this is, guys.
Indicated that we hadn't given them anything, but I thought that I was clear that the discovery was here.
Well, let's keep. I feel we keep getting back to discovery. Let's save that to the end there.
Those are his arguments, Judge, and I didn't want the court to.
Well, right now we're focusing on grand jurors. Let's. I understood. We'll get to that.
Ahead of schedule.
We'll get to that. Let's talk about grand jurors.
Did y'all see that? Did y'all see the way he grabbed those boxes? You really like Mr. Wade? Really?
Right,
do you really?
Here we go.
Your Honor, this goes to my original point, Your Honor, which is the state spends the time to put together a PowerPoint to respond to a motion. That takes a lot of time. I understand. I'm sure it's going to be persuasive. It would be much more efficient for all involved if instead of putting together a PowerPoint, somebody put pen to paper on the team of 8 lawyers here, put it in writing so that we could see the cases, we could move through this argument, and we could get to the end much quicker.
She's like, yeah,
Now
I'm
we're gonna see
proceeding
these
about my
cases from the
business.
state for the first time. Mr. Aurora, Mr. Grubman, and myself will look at these. We'll go back. We'll probably find things that perhaps are inaccurate and have no choice but to then file some supplemental briefing. With a trial date on October 23rd, this process
These
is just
people are
not an
crazy.
efficient use of the court's
These
time.
people are so
The more
crazy.
efficient process here
These
is to write a brief,
people are-
file it, like
Get
they do
a
in federal
therapist.
court all
Just
the
get a
time,
therapist.
like this DA's office did in federal court in this very case in front of Judge Jones, and just file it here. That's my ask.
She can't even get her
Understood. And I think,
presentation started.
again, we're just going to take that up on a motion-by-motion basis. All right, Ms. Young.
If I may approach.
Sure.
To be able to speak to grand jurors. And I think the state and Your Honor are probably on the same page, so I'm going to try to go through this pretty quickly in regards to deliberations, because what the defense motion stated was, and their motion is that they wanted to know if the grand jurors had been read the indictment, and that was the purpose for them talking to the grand jurors. Here today we find that there are some other reasons that they may want to speak to them. But the state's belief is that, it's not moving, as the court talked about deliberation, it is part of the grand jury's reading, whether or not it was read to them, whether or not they read it during deliberations. We're all trial lawyers here. We know that a copy of the indictment goes back with the jurors when it's a trial jury. They're reading over it to make sure that the evidence matches the evidence that's been presented. That's the same thing with the grand jury. They're given a copy of the indictment. They can do with it as they please. And if we start to get into questioning that, we are getting into what they were doing during their deliberations. As the court pointed out, did the foreperson read it to them? Did someone else read it? That's all part of their deliberation process, which has clearly been prohibited by anyone getting into their deliberation process. So the state's contention is that these questions about the grand jury and reading of the indictment summary is part of deliberations, and they can't get into that because it's prohibited. And I'll just cite OCGA 151267 says, the current grand jury oath requires grand jury to keep the deliberations of the grand jury secret unless called upon to give evidence thereof in some court of law in this state. And it talks about extraneous prejudice information, which I think goes towards the Sigmund case, is kind of what they were talking about, as the court pointed out, whether or not the prosecutor was steering them to a particular decision. It talks about outside influences or mistaken entering the verdict. None of those things here exist, and I'll get to their solution as to how they want to handle that with the court. But I'll also state that Federal Rule 606, as well as the 2406 here in Georgia, mirrors that, which basically says the same thing, that the validity of a verdict or an indictment, a jury shall not testify or an affidavit otherwise, nor shall a jury's statements be received as evidence in any such manner. And that gets into what is the purpose of this voir dire that they want to do of these grand jurors? How can it be used?
Voir dire.
According to the law, it can't be used as evidence at trial. They can't testify. They can't give affidavits. So how are they going to even use this information that they received?
Well, we've got this, I think it was the Collin case where an entire indictment was dismissed when people were inside the deliberations. And so I guess the question would be, how on earth is a defendant ever supposed to find out whether that happened without talking to the grand jurors?
Well, Your Honor, we're officers of the court. You can state no one was in there besides the grand jurors.
Yeah.
That's what they're asking for us to do for them. They can state as their place as officers of the court, this is what the grand jurors said to them. We then can state in our place as officers of the court, only the grand jurors was present during deliberation.
So, but in Collin it says the defense presented the testimony of a grand jury witness to support his assertion. And I know it's not really on directed, or that's just kind of in passing a fact that's present there, but I certainly haven't found anything in Georgia law that says no one's allowed to talk to the grand jurors.
Well, and I think it's not that they're not allowed to talk to them, Judge, but I'm basing on what their motion stated.
Sure. And I think we've arrived at the same place there, where it's going to, again, and why I'm kind of seeing that this might all be futile, but I'm with you that deliberations are a hard stop, and I think the defense has conceded that. So really what it all is coming down to, it seems to me, is what are they allowed to be asked?
Right. Well, I'll kind of move on
Okay.
to that point, talking about 204-403 about the relevance. And specifically, LCGA 15-12-73 explicitly states admissions and communications among grand jurors are excluded as evidence on grounds of public policy. So I just think the things that they are asking for gets into how are the jurors communicating with one another. I think it all goes towards how they deliberated. Mr. Grubman got up here and talked. How quickly could they have come to this decision? You know, it's a 98-page indictment. That all goes towards their deliberation. Asking questions about that is part of the deliberation process, which is prohibited. So I think if we're going to get to this point, which the state does not concede we should, we have to figure out then how is it going to be used? Because the case law is clear. Testimony of grand jury witnesses, they cannot use this to impeach their findings. And that's what they're asking to do. They're trying to ask these questions in order to impeach the true bill that the grand jurors set down. That's what they're essentially asking to do, and it's not allowed based on the case law and by statute. And I'll just cite to one case that I don't know if they mentioned, but United States versus Van Eagle. It says an indictment returned by a legally constituted grand jury is presumed to be valid on its face. Similarly, there is a strong presumption of regularity that attaches to all grand jury proceedings. A defendant seeking to challenge the presumption has a difficult burden because it's hard to override, and that site is 809 Federal Sup 1360. So, Judge, I think we have to get into, is it relevant? Is it admissible, the questions that they want to ask these jurors? And based on the case law, it is not, because what they're asking is, we want you to change your mind. We want you to answer a question in a way that is going to impeach your findings. None of the questions that they're at, all of those things are reaching towards that. Was there someone else in there? Did the prosecutor steer you a certain way? All of that is to impeach the finding of a true bill of the indictment. And there's nothing here that says that it should be. I want to touch upon the public policy and the safety that the court talked about. And we've heard it. These grand jurors have already experienced doxing, threats. We've had to they've contacted our office because of safety concerns.
The threat to their
We've
safety.
had to contact law enforcement agencies all over Fulton County to then make sure that these grand jurors are safe. So I think one consideration the court also needs to make in allowing this is the safety of these grand juries and their concerns that have already been voiced. But I'll just say the Georgia Supreme Court observed
as a public institution serving the community,
the grand jury as a public institution serving the community might suffer if those testifying today knew that the secrecy of their testimony would be lifted tomorrow. The indispensable secrecy of grand jury proceedings must not be broken except where there's a compelling necessity. There hasn't been any compelling necessity that's been raised by this defense to then pierce this veil of secrecy of the grand jury.
What was the site for that last one?
Judge.
Where's that coming from?
That would be nice. Kessler, Judge.
And can you spell that one for me?
You have that case, Judge.
That's the one, okay.
Yes.
In my stack. We just pause one moment.
Sir.
All right, y'all. Let me just note that the fact that this woman, Miss Young, is a woman in here really being strong in the stance of Donald Trump and his cronies bullying, okay? The fact that she's a woman, and on top of it that she's a black woman, they are pissed off before she even starts talking. At least they show Mr. Wade a little bit of respect. From the moment Miss Young, like the judge even mentions that she comes on up and take the stance and take her part, they don't do it, okay? She literally just says, I have a PowerPoint. Literally, she just says, I have a PowerPoint. And then you hear her moaning and groaning and chagrin. You know, it's like, literally, this guy hyperventilating testosterone starts hyperventilating again. You know, how dare they sit here and show us PowerPoints that are absolutely unrelated to it. She hasn't even started yet. She has not even started yet. So why on earth would they hand over information of victims to these people? Please explain it to me. Like, are you putting one and one together? So these are the notes that I took. They're aggressive, obviously. Think about the way cowboy boots, yes, I'm going to be calling them cowboy boots, face stuck like that, and hyperventilating testosterone for the rest of this video. Think about the way that cowboy boots took those hard drives, those boxes off of Mr. Wade. Did you see that? Do y'all remember back in the 60s when those sneak volunteers who were trying to make sure that black people in America got their names on the votes? You remember those two white voters' rights advocates and the black guy who got viciously attacked and unalived by the sheriff's office, the KKK, the whole kind of city in this particular city, wherever they were, and they found that car in the river or whatever it was? You know, it's that sentiment of like seething with hate for black people to begin with. I saw that the way that their mannerisms, the way they were looking. It's time to get power on out of the hands of these types of people. But even beyond that, the air of anti-black sentiment, when he took those boxes, y'all, I saw psychopathy. You know, that we're not just, how can you on one hand say that we can trust you? We can trust you to handle victims with the amount of emotional intelligence, compassion, humanity that they deserve, when on the same hand, you don't even treat government officials with the respect. But that shouldn't surprise us, because Trump has made it to where people question the legitimacy and even the authority of the government to begin with. If that's the case, y'all don't belong in an American democracy. Y'all need to go to North Korea or Russia or China. Like, there's no other way to put it. These people are really, really mean. They're questioning the competence of these black people who are clearly very competent. And that's why they are making, it's like whistleblowing. A bunch of whistleblows for the people who are going to receive this, you know. So imagine what's going to happen if they get the contact information of these people in the wrong kind of way. You know, thank goodness that Judge McAfee said, record everything that you do. I also feel like, before she even gets up there, they are conspiring and conspirating, you know. It's like, I hadn't seen them talk to one another more than they did at this one moment while this black, intelligent, emotionally and intellectually intelligent woman was on the stand. And she even basically says it in so many words, like, what is the reason that they want these? Like, she's like, I still don't have a clear reason of why they want these, and it seems like it's for nefarious purposes. She didn't say those words, but that was basically what I was getting for her. There was a need to protect the victims. Them sniveling and whispering like the peanut gallery, like, you know, teenage girls the whole time she's talking. They didn't do that with Mr. Wade. What's happening here? You know? What is happening here? I'll tell you what, it's othering. It's the spirit of othering that Donald Trump brought out when he came into his horrible tyranny. It's time to bring this to an end, y'all. It's time to bring this to an end. I also noted I felt her anxiety. I felt it.
Are you ready, James? And then the state, we kind of talked about Douglas versus Oil, but I just want to point out again, Judge, just talking about deliberations and the fact that it should be, when discussing the charges and votes of the indictment. And I think all of the questions that Mr. Grumman talked about, that's where it's going. So if we're going to do this, which the state, once again, does not believe we should, it's going to have to be crafted very carefully to make sure that we're in line with the statutes and the case law.
All right. Well, I think we've.
And
Oh,
if
I'm sorry.
just one more thing, Judge, because we talked about the grand jurors and the safety, and I'm just, all these cases are in there for the court, but I just want to, we have to make sure that we're keeping that paramount, because they're asking to be able to call these jurors. These jurors have already said we're concerned.
Don't let them
We've
call
had
these
to,
jurors.
and I'm handing
Lord
you
have
actually
mercy.
another copy.
They don't need none of the contact
that,
information.
I gave to the court, but because of public policy and safety, Judge, I think that is another reason why we should not allow this. And then finally, the
allow it.
lack of authority. What they stated to the court was Sigma, which has been vacated. It's really improper to even bring that to the court to say consider this when it's not even law. They've vacated it, they've renounced it.
It's improper.
So it's not even something that the court should even be considering or thinking about. There is no authority that allows what they're asking the court to allow them to do. The indictment, and I've said that to the court, the grand jury acted rather quickly is one of the things, as the court said, we don't get into deliberations with a jury. They can take as long as they like, they can take as short as they like. I understand it may raise Mr. Grubman's eyebrows, but a true indictment was returned by a grand jury, and they could have taken 5 minutes, 5 hours, or 5 days. There's no case law that puts a restriction on how long it should take them. And that's United States versus Van Agel at 808 F sub 1360. And as I stated before, Judge, that there's just a lack of authority for what they're asking to do. And attached in the state's brief, you will find in 2010, Mr. Aurora did the same exact thing. They say they come to the court and they're asking for permission. That's because in 2010, Judge Burnick in DeKalb County admonished Mr. Aurora for the same thing, knocking on grand jurors' doors, asking them questions. She, in fact, had to issue a temporary protective order to stop that behavior. The state is in the process of trying to get a copy of that order. We were trying to do it before this morning, but we will supplement the record once we get that for the court's consideration as to those findings in that particular case.
All right.
Your Honor, I'll let Mr. Aurora respond to the personal attacks that counsel for the state. Speaking of what's inappropriate, it's inappropriate.
Let me just pause right here, Ms. Young. Have you finished?
Is she finished?
Let's let her finish.
Yeah, let's let her finish.
We'll wait.
Jesus.
All right. Ms.
She
Young.
said anything.
Judge, I would say I know you've kind of crafted out some ways that maybe
This
we can do
is
this.
insanity.
The state is not in agreement with that. But if this does happen, the state believes that it should be something that's done with your honor, present, and with just the foreperson. They can get whatever information that is needed from that one person because they are the foreperson.
Put the adult in the room while they're doing that.
If it's done. State doesn't believe it should be done. But with the court present, and if the foreperson asks for the state to be present, for the state to allow to be present, and there are some well-crafted out questions that are given to the court and to the state prior to any of that happening. But
that's what the state and the judge and the American people are saying. Don't trust these people.
Your Honor, I take very extreme exception for Ms. Young coming up here and trying to impugn the reputation of my colleague. If I had to list out the number of cases...
All right, Mr. Grumman, let's keep us on track. I'm not going to
see
consider
that?
it. It's not
You
part
see
of the record.
Your Honor, my colleague was, and this is broadcast live, and that's
you can respond to it on your own. Mr. Grubman, please let me finish.
Okay.
See, don't even
it's
respect
not going
the
to be part of the
judge.
consideration right now. If you want to handle that outside of the courtroom, that's your business. But for now, to stay
Don't
focused,
handle it
I think we
outside
should
the courtroom,
just focus on
Lord.
it.
Respectfully, Judge, though,
Tell the devil to get behind you, Miss Young.
The opportunity, and Mr. Rorschach
Devil, get behind me!
because that was completely inappropriate. There have been many times, that the Fulton County District Attorney's Office,
These people
including
are
some of the
crazy.
members that are
These
sitting
people
in the courtroom
crazy.
today, have been called out by courts by name with inappropriate things that they do in the grand jury and at trial.
Smear campaign.
So no, I
what time is
cannot
it? I
take
think it's
Ms.
time for
Young's
a
word
smear
for it
campaign.
that it was done properly. Ms. Young's trying to send my client to prison, and we have the right to
What about
know
America?
if it was done
your
properly.
client, but what about
and she
America?
keeps saying there's no case law. As Your Honor said, there is case law. Instead of creating these wonderful PowerPoints that they're so fond of, read our briefs.
Infuriating.
The Collin case
Condescension.
says we can talk to grand jurors. So the fact that she got up here and lied,
Do you hear that laugh?
lied to the court.
Is that a tick or a laugh?
Your Honor, she lied to the court, and I apologize, and she defamed my
Mr. Grumman, I've said it's
co-counsel.
over.
All right. Well, I wish you would have stopped her from defaming my
You see there? No respect for the judge even.
So, where we are, let me just summarize.
Hold them in contempt, Lord have
With
mercy.
motion number 1, with the motion to speak to the grand jurors, I would ask defense counsel to supplement their motion. We can do this. I don't think it needs to be, since this is something that would be crafted and considered. We can just do this off the docket. We can do this through email, but just a proposal of the questions, the topics that would be gone into, and if we need to follow this up with another hearing to actually hone those, we'll do that. But I think for each question or subject matter you go into, I'm going to want to see a citation for how this is an actual relevant line of inquiry. All right, and then we can get into the logistics from there, because I think there's a way to accommodate the case law cited by the state about the general secrecy, but still allowing the defense their ability to make sure that the grand jury fulfilled its duty in a manner recognized by law. As for the motions to unseal the grand jury transcripts, I think we'd mentioned that I'll be taking that under advisement, and I've been provided the case law for these first 2 motions. Ms. Young, if you could provide a copy of that PowerPoint to the defense and to me as well, and counsel for 1 and 2, were you desiring supplemental briefing on that to respond to what we just got?
I think the case law is the case law. If you read it, you'll understand.
All right, Mr. Rafferty, did you want to respond?
No, Your Honor, I just would echo what I said before. I would just ask.
Oh, now he's calm.
Would deliver on a case-by-case basis.
He's not hyperventilating now. What's
intends
up?
on drafting something like they have today and they did last week in the form of a PowerPoint, that it be in the form of a motion that we have an opportunity to read and be prepared so that we don't waste the court's time.
Waste whose time?
And then finally 3 was mooted. So I think that takes us to just another kind of check-in of where we are. Just a few things on my end before I know we can start talking about some discovery issues and we wrap up. Obviously, I think it might have hit the docket by now. I think sometimes, like I said, sometimes there's a kind of like a delay, but we filed an order on the severance issue. I realized I never actually asked the state at the last motions hearing about the redacted indictment issue that Mr. Aurora argued and that was filed on behalf of Mr. Chesebro. If you recall, it's the motion to sever counts from the other defendants. Yeah.
1 second, Jay.
Let's see. The August 30th motion for severance of co-defendants, and it lists several of the counts. And essentially how Mr. Aurora clarified it was that he's asking for a redacted indictment at trial. I never actually got the state's position on that one.
Your Honor, John Floyd for the state. Mr. Wooten addressed this originally. He's not here at the moment, so I'll just step in and pinch hit for just a second. As I recall the nature of that motion, one part of it was to sever individual defendants from each other and from the larger case. The subsidiary question was whether specific counts would be severed from the indictment. I believe that's what
I think that's how it was phrased, but then when we discussed it, where it's just where these motion hearings can be useful, it evolved into more of just we'd like a quote-unquote dummy indictment at the actual trial of the case. That's at least how I interpreted it. Mr. Rohr, is that fair?
Yes, Your Honor, and I'm sorry if I didn't write it correctly, but just like I thought you granted it, just like we do in other cases when the defendants aren't there, you white out or redact make it a dummy. That's what I'm asking for. And I told you I would file separate motions with regards to any of the counts substantively if we wanted to.
So maybe this is something more we address as like a pretrial motion in limine, but it's not so much as I take it, and off that, a motion to tailor the evidence or what the state's allowed to present, or that those other counts aren't relevant. It's more just what is the document the jury should get.
I understand, and if I misunderstood it the last hearing, I apologize, because I wasn't trying to add confusion to a complicated situation already. We don't, the state, just for the record, don't see any basis to sever out any individual counts as to any defendant, but that I think is not what Your Honor was addressing now. And I'd suggest this is an issue that we can talk about and get to later. We're still, I realize that we're not talking about a lot of days, but we're certainly not yet talking about what will go out to the jury, especially since you've been told you're going to be getting dispositive motions. And so it's somewhat hypothetical.
All right. Well, I just wanted to raise it that I hadn't entered an order on this one, and I hadn't heard the state's position. So,
Right. Thank you, Your Honor.
Is it safe to presume it's sort of granted, and we'll just work out how to sanitize the indictment? That's all I'm looking for.
we'll get there. We'll get there. Well, it's still a lingering issue.
I'd like to see an order sort of granted.
We'll work on it.
I'd rather not see something like that because it's very difficult for us. But thank you, Your Honor.
All right. So other housekeeping. I think we're going to get. I just wanted to flag this as well, just again because we're on this compressed timeline. We'll get more into the mechanics of jury selection at the case management hearing later this month. Obviously, those are conversations we're starting to have with the court administration and the sheriff's office and that sort of thing. But I did want to flag that the state had filed a motion to use a jury questionnaire. I think that's absolutely appropriate here, and I think it's going. I don't think you need to. We'll do it. And so, we'll probably have the deadline to submit those questions several weeks before.
Judge like, nah,
so,
we'll do that. It's
maybe go ahead and start crafting those now.
I had spoken with Mr. Wooten last time, and we didn't necessarily agree, but at least talked about the possibility of getting together and trying to craft questions that we all might agree on, and then maybe having two separate sections.
They are incapable of falling back.
Ones we don't want, and vice versa. We could submit all that maybe in the joint filing period.
That sounds wonderful to me. I also want to flag that as I highlight more in the severance order, we're going to make an attempt to, because I think my initial review of the speedy trial case law is that it's somewhat uncertain of when a trial commences. And so we're going to be making the attempt to have this jury sworn by the deadline of November 5th. Maybe that means a weekend or two is involved. But regardless, I just want to warn you when it comes to the questions you submit on there, we're probably going to have to adopt the federal practice of a clock and a timeline. And you have so much time per panel, and however you want to use it to see fit. And you can ask 100 questions, but you may not be able to follow up on all 100 of them. So I just want to lay that expectation out there.
On a different topic, can I give you the court something to think about?
Sure.
So there's a trial going on right now. Actually, the jury's deliberating now in federal court. Several federal judges, and then I have a case up in New York, have done a modified trial schedule. And just if you could hear me out, it's just something the court might consider for a lengthy trial like this. And I think we're stupid. But basically, I think they go from 8:30 to like 3 or something, like 8:30 to 2:30, 8:33, something like that, with maybe 1 30-minute break, 2 15-minute breaks. And what the judge in that case told us through years of research, he's a senior judge, is he said if you look at the transcript pages, you actually wind up basically getting the same amount of words in at trial. But particularly for a lengthy case, the state said 4 months, not including jury selection. It just might make things more comfortable. So maybe if the court would entertain like an alternate schedule instead of just 9 to 5, that just might be something that makes everyone a little more comfortable, particularly for jurors. We're going to have to be here, for I think the court said maybe 8
Oh, now
months.
he's sweet. Now he's being sweet.
And I could,
When you say modified, you mean just a shorter day?
Shorter day. It starts a little earlier, ends earlier, fewer breaks in the middle. It tends to get things done quicker, and I was very skeptical of it when it was proposed to me in another case. And then actually another lawyer I know just finished a 2-month trial, 2.5-month trial in federal court, and they went on that, I think it was Judge Batten, went on that schedule, and the jurors apparently absolutely loved it. The court loved it. It just made things a lot easier. So something to consider, if you would.
All right. Well, we'll see. Initially, the reaction was going to be 4 full days a week. We follow the APS precedent of taking likely Friday off to handle other business and let the jurors recover. And in terms of a strict, we shall have a break at this point in the morning and that point in the morning. So far, I've found that jurors'
it's been like a
personal
minute.
needs don't really run on a clock like that, and so we kind of have to take the breaks where they come. And so we'll see. But the idea is going to be 4 full days, at least a week, when we start getting to the evidence. But I just wanted to flag at this point that voir dire might be very different than what we've seen here in the courthouse before by necessity?
Well, yeah, we are aware of the case. I mean, I think the case law is pretty clear, Your Honor, when a trial starts, so we're aware of that issue, and we won't do anything to unnecessarily delay it. I do think the court picked up on. It's clearly going to be a challenge. I don't know that there's really anyone in Fulton County who hasn't heard of this case, and I don't know that there's anyone that doesn't have a strong opinion one way or the other about, the former president and the people who associated with him. So we recognize the challenges, and we will do everything possible to move as quickly as possible. Hope the state will join us in that one.
All right, Mr. Wade, just if you wanted to add anything, feel free. But otherwise, I'm just kind of going through some housekeeping issues here.
We have every confidence that the court is capable and qualified to set the trial schedule, and we'll adhere to whatever the court is.
All right, but I'm open to input anytime. All right, and then the last thing I would say is obviously seeing the new motions that have come in the door. Mr. Rafferty might be pleased to hear that I will absolutely be hoping for some pre-hearing briefing on the Supremacy Clause issue and likely the immunity issue as well. Although I don't think Ms. Powell joined on the immunity yet, but perhaps.
Not as of yet, Your Honor.
Yeah.
If I might, I do have that Brady concern that I'd like to raise.
Right, well, that's what I'm leaving for. That's
all right, y'all. So the last one I did, I was pretty sure that the judge was going to weigh of no severance. I was pretty sure he was going to deny severance, at least partially deny it. But actually severance was granted to Mrs. Powell and Mr. Chesebro. Like they're sorta. It's like they're separated from the other defendants, and Donald Trump, they're saying he most likely will go in 2024, which to my opinion is a huge, gigantic mistake. But let me just go ahead and say this. Also, there's a point where Cowboy Boots mentions the cases going on in federal court and in New York and how modified timelines have been presented. At that point, I was like, oh, really? Now y'all want to actually mention the whole gestalt of the whole thing. Very, very interesting. Let me just say this. I felt this black woman's anxiety. The sister, I felt her anxiety before she even got up there. And what that says to me as a black woman is that she has been being harassed, either emotionally, either through veiled threats, either through aggression. But I know that I know that every person of color, every LGBTQ person who has lived in America in the past 7 years, almost every one of you guys knows that anxiety, because this is the nature of the energy, the tone, the environment that these people have brought into the country, and it needs to go away. We've all been feeling that since 2015, and you're not crazy for it. I would urge the judge and the state prosecution and every American to look at the bigger picture here. Okay, this is just Kenneth Chesebro and Sidney Powell, but the whole MAGA criminal enterprise attempted to overthrow American democracy, is still attempting to do it, is still attempting to get a criminal as a bigot into the office, the U.S. office, and it is not right. We basically have to stop this thing where we're fighting one another so much that we can't even focus on fighting very real foreign threats that are out there. There's also just this air of othering. Before she even got up there, you felt this anger. I want to mention, I think in the last video where we talked about this, I said John Floyd, but I guess it must have been a representative for John Floyd, because John Floyd got up and spoke today. At least I think this was Mr. Floyd. I'm sorry if I'm fudging on these names and stuff. Like I said, I'm not a lawyer. But white dude in the gray suit gets up, and Donald Trump's allies, the Sidney Powell and Kenneth Chesebro's team, they're not acting all indignant this time. They're not acting all aggressive. So why is it when Miss Young and Mr. Wade get up that they act all crazy? Why? Because for a long time we have excused xenophobia, racism, bigotry, sexism, anti-gay sentiment, hate crimes, and anti-Jewish sentiment. It's time for this to stop. I think it was very admirable how the judge smacked down Cowboy Boots' BS immediately. And I hate this fake sanctimonious stuff. Victim blaming. One of the reasons I want to follow this is because I didn't know about all the victim blaming going on when Johnny Depp and Amber Heard's trial went through. Like I said, I'm not a lawyer, but I feel like it's every American's moment. Right now, it's for every American in this moment to stand up to fascism. We dropped the ball. We screwed up because we didn't stand up to fascism over the past 7 years, because arguably a lot of us didn't know that's what it was. A lot of us before 2015 didn't experience anything like this because we weren't born in 1950 U.S. or born in 1930 U.S. or born in 1915 Germany or born in 1930, 1940 Germany. You know, like, it was new for us. But now we know what it looks like. We know what authoritarian and fascism looks like. And if you don't denounce it with every fiber of your being right now, the soul of America is at stake. Again, they don't talk about the victims at all in this. Oh, my advice to the sister, just breathe. Just breathe, girl. Just breathe. I know that feeling. She feels threatened. You know, she feels threatened. Maybe they aren't threatening her with violence, but you know that all of that sanctimonious BS is dog whistles for people who probably can get violent. So why do you think they wouldn't want to share victims, the parts of the jury? Why would you think they wouldn't want to share their contact information? The PowerPoint. She has every right to do a PowerPoint. You know, they're sitting there disparaging her. Othering. They think she should be barefoot in the kitchen.
So, Your Honor, I've been in this case probably for a month. And on August 30th, shortly after I got into this case, I sent a very detailed Brady request to the government. Those Brady obligations, as Your Honor knows, are independent of their discovery obligations as it relates to this hard drive. They have a due process obligation to turn over to me favorable information. And I didn't send them some blanket request saying, give me everything under the sun. It was a very, very pointed request on August 30th that addressed two critical issues for Ms. Powell. That is, number one, that she wasn't behind this incident in Coffee County, which forms the basis of her inclusion in this indictment. And number two, that whatever happened in Coffee County, there's ample evidence out there that it was authorized. Okay, so I've asked for that very specific evidence. In response to my letter on August 30th, I heard nothing from the state. And so this week, I sent an even more tailored request, a copy of which I can provide to Your Honor, asking for very specific information, because I've spent the past month or so trying to figure out what happened and have gathered ample evidence showing those two things, that Ms. Powell was not behind all of this and that it was authorized. I filed a motion last night that sets out all the evidence that I've been able to find on my own, which I hope the state has, okay? But the most important thing that I found, Your Honor, is a report by CNN, which I've been able to confirm, that there is a letter of invitation from Coffee County on January 1st of 2021 that was sent, and it was sent not to Ms. Powell. It was sent to another lawyer, inviting folks to come down to Coffee County and do whatever it is that they do. What does that establish, Your Honor? Two things. One, what I've been saying since last week in my severance motion, what I said in my motion last night, what I'll keep banging the drum on, which is this was not Ms. Powell. That's number one. But number two, that this was authorized. It was authorized, and I have asked for that. I have not asked for 8 terabytes versus discovery. This is a handful of documents. We've got 8 lawyers sitting on this side. I'm pretty sure they know how to attach a document to an email. But in response to that email that I sent this week, like my letter I sent in August 30th, I heard squat from the state. So they sit here and say, Your Honor, that they are open and they're going to turn stuff over. I have been as clear as day about specifically what I'm entitled to under the Constitution, due process, Brady versus Maryland, independent of any discovery obligations they have. That is exculpatory information that establishes that Ms. Powell should not be in this case. They have it, Your Honor. I have a reason to believe they have it, and they don't even respond. I have a motion. I'm going to file it. I'm going to ask for this relief, but I shouldn't have to file it. If this were in federal court, Rule 5, Your Honor would issue an order upon arraignment, ordering them to turn that material over because they have
to. It's like a child's tantrum.
They don't have a choice, and they haven't done it here. I'm concerned. Ooh. I practice mostly in federal court with federal prosecutors who know that. I have concerns that Mr. Wade and the other folks on this side don't appreciate their Brady obligation. So I'm asking the court to order them to produce Brady material immediately because they're required to. That's my point, Your Honor. I'm concerned. I raise it with Your Honor, and you'll see it in my motion.
All right. For the record, Your Honor, we have also not received any Brady information. There's a lot. We know there's a lot. Mr. Wade and his team, who are open and want to send us everything, have not sent us one page. That's the record.
All right. Well, so, Mr. Rafferty, you don't have to stand. I'll just point out, I think in terms of the timing of the motion, the way we try to keep things as on track as best we can, that we have the final drop dead date of when they're supposed to have gotten you everything that is supposed to be turned over. And at that point, if you still don't have it, that's when that motion becomes absolutely relevant.
I understand.
In the meantime, I'm hoping that there's an exchange and a dialogue, and things can be worked out among attorneys. But that's the idea. But note your concerns, and let's see what the state has to say, and then we might just have to leave it at that for now.
And my point is, Your Honor, this. There is discovery, which is governed in federal court, as you know, by Rule 16, by state court procedures that are the equivalent. I understand Rule 16. I understand discovery. Independent of those discovery obligations are their constitutional obligations under the Due Process Clause to turn over exculpatory information and to turn it over immediately.
Well, and there's no question. I think we're really just talking about timing.
And
right?
Your Honor, I understand that. It has been weeks now. They haven't even responded acknowledging they have those obligations. They haven't turned over the information. I refined the request and specifically told them, these are the pieces of paper I want. I haven't even gotten a response to the email saying, okay, we understand. I haven't gotten a single piece of paper. I don't need 8 terabytes worth of discovery.
Okay,
I need the
so
stuff that
Mr. Wade
proves
is going to
that
get
she
into
should
this
not.
later. He basically is saying, oh, it seems like you guys want some spoon feeding. But beyond that, this is that entitlement. This is that persona that I've talked about often, of that entitlement, that hyperventilating, just like sanctimonious, fake sanctimonious too. And there's no emotional intelligence. It's almost like a person who's on the spectrum. There's all these social cues that are coming out and they're just bulldozing over them. He's aggressive. He's threatening. Just hearing him talk, I don't know about you, but in me, it invokes anxiety. It invokes anxiety. It invokes just that feeling in my stomach where it starts turning and it feels like I'm about to vomit. I feel like that is what the state prosecutor really, really feels. The only other times that I felt that right there is when I've been in the presence of an extremely racist person or people. This has happened several times with me over the past 7 years, more than I had ever experienced in the first 25 years of my life. Honestly, I really never experienced racism in my life until after 2015. And it's always been that feeling right there, that feeling of your stomach turning, your anxiety. Your body tells you when stuff is going on. It's up to you to listen to it. This man's body is telling him something is going on. That's why he's hyperventilating like that. But he's not listening to it. And then I just want to point out the hypocrisy here to talk about the Constitution. He's talking about it's my constitutional right to get exactly what I'm asking for, exactly the way that I asked for, when I say it, first of all, who are you? This case was brought to you, to the American public from the state prosecutor's office. First of all, they hate that. They hate not having the upper hand in this. The dynamic is a little bit different when something is brought from the district attorney, but they don't respect that authority. They don't respect this authority. But let's talk about the hypocrisy for him to be talking about it's my constitutional right to receive this information. It's against the Constitution to lie about an election, okay? It's against the Constitution to conspire and cajole and threaten to turn over an election falsely. It's against the Constitution to cause an insurrection. It's against the Constitution to try and make America a communist country. If you want to live in a communist country where the ball game is just for a certain group of people and they control all the power, go to those communist countries. But America is not a communist country. So I don't get it. Beyond that, hyperventilating dude is there's anti-black sentiment in what he's saying. They have to, there's entitlement. They have to. And I'm going to do a review very soon, if I have not posted it already, where a very, very famous narcissist expert commented way back in 2017 that Trump is, even though he's, has been a president of the United States, is a reality TV star, former reality TV star, has garnered all of this money, all of this power. He is the classic example of a narcissist. And arguably almost everybody who was under his tyranny in their little lines of rank are also narcissists. And narcissists do not care about other people. That's where it gets dangerous, because it's basically like you're dealing with the sentiment of a child. Like a child throwing a temper tantrum until they get what they want. A child will throw all of their toys around a room because they don't get what they want. But an adult can do something much more violent and worse. This is even more of a reason for them to take all necessary precautions in protecting victim, jury members, jurors, their contact information, sensitive information, their families, keep their families and them safe. Because these people clearly don't care about anything dealing with emotional intelligence. Nothing. Distraction. I want to speak on distraction. As soon as hyperventilating dude is done with his spiel, and again, he doesn't show any respect to the judge, really. I mean, you're going to see in a second, the judge basically doesn't take the same technique that he did with cowboy boots. He basically just doesn't even entertain all that hyperventilating craziness. But it's almost like, how can you? Because he spews out so much insanity in a short amount of time that it's like, how could I even respond to all of that? It's like you walk away from it thinking, where am I? Who am I? What's my name? I don't know where I am. You know, that's like how when this guy is done talking, hyperventilating dude. But even as soon as hyperventilating dude stops speaking, Cowboy Boots jumps in. Cowboy Boot jumps in. You know, it is that exact technique of misdirection. You know, it's misdirection.
Judge, respectfully, Judge, it appears as though Mr. Rafferty wants us not only to provide the information to him, but to spoon feed it to him. That information has been provided this morning on the terabyte drive that he's been handed. Before schedule, ahead of time, the court sets a discovery or a pretrial motions order, a pretrial track for which the state has held true to. We have not violated any of the deadlines. What we're doing is trying the case is what we're doing. That's the attempt. They're putting in evidence, and he's saying these things, trying to essentially try the case before it's time to do that. Discovery has been given to the other side, Judge. It's been given to them actually, not just timely, but ahead of time, ahead of the schedule that the court has set. Now, all Mr. Rafferty has to do is plug it in and open it and find the documents that he's looking for.
All right. That's the key, Your Honor. If I could just point this out. And let me educate Mr. Wade for a second. As a former federal prosecutor and a state prosecutor, you do not satisfy your Brady obligations.
Right here. You hear that? Let me just educate Mr. Wade right now.
8 terabytes worth of material and say, go find it. That does not satisfy your obligations under Brady, the case law, and the Constitution. You are obligated to turn over specific information that has been requested. You can't just give me 8 terabytes and say, have at it and go find it. If you have it and I've told you what I'm looking for, you got to turn that over to me in that form.
All right. So I think we're spinning our wheels at this point. Mr. Rafferty, obviously on that specific point that they have to then kind of point to this and that and respond to discrete evidence requests, make that a part of your motion, because I'd like to see the case law on it, and we can take that up at the appropriate time. In the meantime, I think in order to, there's a lot that needs to be done between now and October 23rd, and I think the best use of our time isn't being in court here talking at each other. I think that acknowledging an email, replying back to it sometimes could prevent us from being here as often as we may have to. So to that end, I would encourage everyone to keep the lines of communication open, and we'll take the motions up at the appropriate time. So anything else that we need to hear today?
Judge, if I may, I just give you a copy of the case law.
Okay. And this is something you'd already provided to the defense? Okay. All right. And well, when it comes to scheduling, I wanted to address this grand jury issue early on in the case, since there had to be some follow-up investigative work. But I don't think we would need to make this a weekly recurring thing for now. We could wait until the discovery deadline passes and the motions deadline passes and then start scheduling the rest of these hearings. So that's the plan.
Your Honor, on that kind of scheduling, if it's possible, if we have to have a hearing next week, could we have it Monday, Tuesday, or Wednesday? That's my request.
I know next week I'm presiding, and right now Wednesday looks mostly clear.
Thank you.
So that could be a date we could shoot for if there's some kind of emergency that has to be heard.
Thank you.
And we could even try, Mr. Roy.
Oh, sorry, I was changing topics. Are you done?
Oh, that's fine. Yeah.
With regards to the scheduling order, I think there was a September 20th deadline, and traditionally 1716 4B1 says once we get to discovery, we have 10 days to respond.
Mm-hmm.
I guess if we got it today, could we have our 10 days starting now for me to respond? Because I don't know what to turn over to them until I see what they have. Is traditionally how it works, but I know we're on a compressed time schedule because if we all turned it over on the same day, it wouldn't really make any sense because I'm not sure what it is I need to, address as far as our case goes.
Well, I hadn't heard that one before. I think generally the intent of the scheduling order is that there is a mutual exchange by that date, and that if there is then supplemental discovery because it's newly discovered or newly becomes relevant in good faith, then it gets turned over within 5 days, I think is our general guideline there. So I think you, based on the indictment itself and the arguments we've had so far, have a pretty good idea what the state's case is against your client. And so I would think that you could turn over the bulk of your discovery by that deadline. If there's some follow-up that needs to be done and the state's unsatisfied with the timeline of when it's turned over, then they'll file a motion and we'll hear it.
I just don't want to have any bad faith issue. I don't want to pay experts if I don't need them based on what the discovery says and what witnesses they have since we've got it today.
Well,
running out of money,
experts
y'all.
will be classified differently. I think we
Donald
also have
Trump
a
turned
trial,
out the tap, y'all.
management order where we say experts are supposed to be identified and summaries of their reports. I believe it's 14 days. It might be 7. We'll take another look at that, but that's in a different category.
Traditionally the statute actually says once government gives you discovery, you have 10 days to do it or X number of days before trial.
Oh, Lord, these people are crazy. These people, please don't give them the power anymore. Get them on out. Get them on out. Okay? Get them out of the government. Get them out of the law. Get them out of the courts. Get them out of Congress. Get them out of the House. Get them out of the Senate. Get them out. Out.
Sit through 140 of them and maybe cross-examine 10 in the trial. So I'll just watch movies or something. But, in the interim, I'm just trying to figure that out. And so.
Understood. Well, obviously, like I think you've kind of already alluded to, if after this discovery deadline is passed, then you've got a smaller batch that you think now needs to get turned over, then do it. And it should be still I don't know about well in advance, but it should still be enough in advance.
It's just not new, and I didn't want you to say.
Sure. And if the state has a problem with it, then we'll take it up, and then we'll just have to see what the arguments look like.
With regards to the more substantive motions, being the supremacy clause, the RICO, the justification, and there's a First Amendment and an anti-SLAPP type motion coming as well. I think you've said that they would probably be required to write it. I'm going to have witnesses for that, so if we could set that out so I can fly the people in as far as that goes, that would be
okay. So at the case management hearing, we're going to want to go into how many witnesses, how long you think each hearing is going to take, and then we'll start setting some dates.
And then the last thing is, depending on how some of the rulings go, there may be some interlocutory requests for appeal. I don't want to screw up the jury selection or whatnot because that stops the tolling or tolls the speedy trial. Explaining that may be an issue because some of these are somewhat case dispositive, at least the RICO and things like that. So,
Understood. We'll take those up as they come.
right.
Anything else?
Thank you, Judge.
Thank you all.
All right, so let's talk about this, guys. People, they take stuff as they come. That's what the judge ended basically with saying. We'll take these things as it comes. And MAGA, they don't like stuff like that. They want everything so that they can scrub it and use it to their advantage as much as they can. Nothing is about the American people. Nothing is about the sanctity of democracy. Please don't let these people get anywhere near the victims who have been through so much, the jury members who have been through so much. They don't respect the judge. It's very clear that they don't respect the judge. They respect him a tad bit more than the state prosecutor's office because he's a white dude, and it's either that judge has the patience of a saint. Because, after the way that some of these people spew hate at him, the way they spew hate at everybody, for him to be able to maintain his dignity, respect, and composure is something. Out of all of the Powell and Chesebro's team, which is so weird because it's like they're arguing for Chesebro and Powell, but doesn't it seem like they're just arguing for Trump? Do any of you guys also have that feeling as well? I just feel like this is all about Trump. So that's how I feel like this is coming from the top down. I also want to talk about emotional violence. I talk about narcissists a lot on this channel, and narcissists' game is they don't physically batter you. Sometimes they will. those are usually psychopaths mixed with narcissism. But narcissists, pure narcissists, they usually don't batter you physically. They batter you emotionally. That is what Donald Trump has brought out in the GOP. You know, I think after this is all over, and someday it will be, we're seeing the start of that with all of these cases. So guys, do not be fooled. You know, even though I'm disappointed, I wish that the FBI, the Supreme Court, the federal courts, the state courts, I wish they would have gotten involved earlier and gotten Donald Trump out of power earlier, because clearly he is unfit to lead, and he is leading the country into a very violent, bloody place. And people are so ready to follow his orders, you know, that it's just like that supply needs to be cut off from him. And a lot of the problems that we have with his faithfuls will disappear. But after that, you know, after Donald Trump has received, and all of his cronies have received the justice that they deserve, whether that be, you know, impeaching them so they can never run for office again, whether that be, you know, eliminating the chance for them to hold public office again, whether that be impeaching, whether that be firing them for their position, whatever it might be, you know, removing them for power, for the sakes and for the purposes of this, the sake and purposes of this, I'll just say removing them from power. Whenever that happens, there is going to need to be a deep concerted effort of healing for the United States of America. Because don't get it wrong, we have been deeply wounded by this. Deeply wounded by this brush with tyranny, authoritarianism, fascism, autocracy, however you want to call it, of Donald Trump. And we are going to need deep healing. And that will start with a focus on mental health. I thought that, I don't know anything about the law really, but they said voir dire, which is French. You guys know I live in France. Voir dire actually means see, to see, to say. So I would be really curious to know if any of you guys know exactly what that is within legal, you know, environments. I would love to hear in the comments. Yeah, basically we saw a lot of black and white thinking here, which is what MAGA is famous for. We saw very little emotional intelligence for the victims in all this, which is what MAGA is famous for. Yeah, they really like routines, narcissists. And so basically they just said, do exactly what I want, when I want, and everybody will be okay. But usually everybody is not okay, even if you do everything that they want. So, yeah, they don't consider victims. Yes, after all this, America's going to need some deep healing. Guys, I hope y'all are eating right. You know, a lot of this stuff can be so emotionally draining. Eat right. Eat a lot of vegetables and fruits that came from the earth, not from containers. Eat some good proteins, lean proteins, hopefully, like fish and chicken, turkey. Take your vitamins. Do some mindful meditation. I really hope that that entire team of hyperventilating, cowboy boots, and face stuck like that will really do some mindful meditation. Go to yoga, because they really need it more than anybody, but we all need it, okay? The U.S. is going to need all of it, honey, all of it. Vitamins, mindful meditation, yoga, therapy, everything. But it's coming into justice. Trump and his allies are coming into justice. When it's all over, you know, over. Of course, there'll still be these stragglers and exceptions of extremists who remain behind after this is over. But when, because it will happen, when this is all over, the U.S. better invest deep into some anti-fascist initiatives, the way that Germany did, the way I said it before. They better invest some deep money into that, and they better invest some deep money into mental health. And, oh, you already know it, CRT and DEI. So, yeah, I want to know what you guys think. Let me know in the comments. We'll keep coming back and talking about these as they develop, you know, these hearings. But I want to know what you guys think. Let me know in the comments. And if you're new to this channel, go ahead and hit the like and subscribe button. Hit that bell so you know whenever I post a video. And I'll see you guys next time. Bye. Bye.